The best thing about being a member of CIArb is being part of a community of ADR practitioners where one gains access to professional development opportunities through seminars, workshops, and accreditation courses, as well as access to networking opportunities for conferences and social events.
We offer a range of courses which equip people with the knowledge and skills that they need to avoid, manage, and resolve a dispute, because we believe these are fundamentally important skills for people to learn.
The courses that I've taken through the Chartered Institute of Arbitrators have all been led by very senior practitioners. So also as a senior practitioner, it gives me an awful lot of opportunity to learn more, much more than sitting in a classroom and listening to someone speak.
Well, I'd recommend the CIArb training because it's very thorough. It's recognised as a gold standard, and so having the qualifications will help you in your career.
First of all, one of the benefits of being an associate at Chartered Institute of Arbitrators is an opportunity to visit events and conferences on highly interesting topics. You're not only engaged in discussions, but also you receive plenty of networking opportunities.
Not only was I able to attend events with leading practitioners and scholars in the field of international arbitration, but also Ciarb allowed me to meet other students from all over the world with similar interests and thus develop further networking and professional skills.
Welcome to everyone joining us around the world for the Chartered Institute of Arbitrators CIArb's annual Roebuck Lecture, which will shortly be delivered by Lady Justice Joyce Aluoch. My name is Catherine Dixon and I'm CIArb's Director General. I take this opportunity to warmly welcome Judge Aluoch and CIArb's President, Anne Ryan Robertson, who's joining us from America. This is my second Roebuck Lecture, and I remember the first, in which I nervously gave the opening address shortly having joined CIArb. I certainly couldn't have predicted the year we've all faced and the changes we've had to make because of the pandemic. However, despite the pandemic, dispute resolvers around the world have risen to the challenge, changing and adapting their practice to meet the needs of their clients in a changing world. CIArb has risen to the challenge too, and has continued to grow its membership around the world to over 17,400 professional members and over 9,000 student members operating in over 150 jurisdictions with 41 branches run by members for members. I'm proud to lead Ciarb as a mediator and lawyer as we support our members to effectively resolve conflict and disputes, thereby supporting the rule of law, access to justice, and importantly, as we hopefully start to emerge from the pandemic, enabling business certainty, which is crucial to economic success. This year, we launched Ciarb's new strategy, which aims to globally promote the constructive resolution of disputes, be a globally inclusive thought leader, and to develop and support an inclusive global community of diverse dispute resolvers. We're committed to supporting equality, diversity, and inclusion, enabling the best to join us irrespective of their background. If you haven't joined already, I hope you'll do so. This is the 11th year of the Roebuck Lecture, which is in honour of Professor Derek Roebuck, a former member of CIArb. Derek, who very sadly passed away in April 2020, was a senior research fellow of the Institute of Advanced Legal Studies, University of London, and was the editor of Arbitration, the International Journal of Arbitration, Mediation and Dispute Management, which is at the forefront of development in alternative dispute resolution. This lecture is a very fitting way to honour the significant contribution Derek made. Judge Aluoch's lecture theme is the impact of the Singapore Mediation Convention on mediation and arbitration. It could not be more pertinent given the changing world we find ourselves in. The convention is an important milestone in the evolution of commercial dispute resolution, and Ciarb has encouraged its developments since it was first launched in August 2019. The convention is important not only because it enables enforceability of settlements reached through mediation, it also has been referred to as a rallying point for the promotion and use of mediation as a common method of resolving disputes. In this way, the convention could play a unique role in the creation of a wider suite of options for parties looking to resolve their disputes by normalizing the use of international commercial mediation. There are fascinating questions around the details of the convention and what implementation will look like in practice, and we look forward to hearing more about that from Lady Justice Aluoch today. Implemented properly, the rise of international commercial mediation could serve as a valuable complement to international arbitration. Indeed, it's this kind of complementarity between different forms of dispute resolution that Ciarb is eager to promote as a way of better meeting the needs of parties. We're supporting the adoption and ratification of the convention by governments around the world. In particular, we're working with the UK all-party parliamentary group for ADR to encourage the UK government to sign up. Just before I introduce our speaker for this evening, a few housekeeping issues. Ryan Robertson, Ciarb's president, will be asking our speaker, Judge Aluoch, questions at the end of the lecture and giving closing remarks. If you have a question, please put it in the Q&A box, not the chat. Please use the chat function to chat. Maybe tell us where you're from and your role. It's wonderful to see how diverse our audience is at these events. And we'll try to get through as many questions as possible, but please don't be disappointed if we don't have time for your question. It now gives me immense pleasure to introduce Lady Justice Joyce Aluoch EBS CBS MCIArb. To many of us, Judge Aluoch needs little introduction. Judge Aluoch served as a judge on the International Criminal Court in The Hague in 2018. Judge Aluoch is also a former judge of the Kenyan High Court and served as a member of the Court of Appeal. In addition to her career as a judge, she was the first chair of the Committee of the African Union Experts on the Rights and Welfare of the Child and the vice chair of the United Nations Committee on the Rights of the Child from 2003 to 2009. She played a pivotal role in the negotiations between the African Union and the government of Sudan to ratify the African Charter on Securing the Rights of Children, pursued a fact-finding mission to war-torn Uganda on the effects of war on the child, and chaired a task force aimed at handling sexual offences in Kenya through the implementation of new legislation. Judge Aluoch is also an international mediator and, of course, a member of Ciarb. Welcome, Joyce, and thank you for taking the time to speak with us this evening. Thank you.
May I start by thanking the Chartered Institute of Arbitrators, London, for giving me the opportunity to give this year's Roebuck Lecture. I'm most grateful. Now, the topic of my lecture is the impact of Singapore Mediation Convention, both on mediation and arbitration. One thing I'm aware of is that not everybody who has logged in are ADR practitioners. ADR simply means alternative dispute resolution. There are some people who are not ADR practitioners. So if I spend time explaining a few things, please bear with me. ADR practitioners, I hope you will bear with me. Now, some of you who are logged in, I believe you are at the signing ceremony in Singapore. There it is, the Singapore Convention signing ceremony and conference. Now, I want to say, maybe I just better start by saying that a convention or a treaty is an international agreement between different countries that is legally binding to the contracting states. Because some people might be saying now, what is Singapore Convention? That is what a convention or a treaty is. The Singapore Convention applies to settlement agreements resulting from mediation concluded by parties to resolve a commercial dispute. Now, the Singapore Convention could not have come at a better time than now. Why do I say that? I say so because the timing of the entry into force of the Singapore Convention is most convenient given the disruption by COVID-19 pandemic worldwide, including international commercial transactions and the increased need for expeditious resolutions. Now, talking about the Singapore Convention particularly, December 20, 2018, the United Nations Convention on International Settlement Agreements resulting from mediation, that's the long name, but is commonly just known as Singapore Convention. It was adopted by United Nations General Assembly. 7th August 2019, the convention opened for signatures in Singapore. That's the slide I showed you a minute ago. That's the day it opened for signatures in Singapore. Now, on that day, that first day, 46 states signed the Singapore Convention. To date, it has been signed by 53 countries, including 3 of the world's largest economies, US, China, and India. September 12, 2020, the convention entered into force. That was 6 months after deposit of the third ratification instrument by Qatar, following Singapore and Fiji. Currently, the convention has been ratified by 6 countries, namely Singapore, Fiji, Qatar, Saudi Arabia, Belarus, and Ecuador. In February of 2021, that's February this year, Turkey enacted a law regarding the approval of the Singapore Convention. The law entered into force on 11th of March. Pursuant to Article 14 thereof, the convention shall enter into force in Turkey 6 months from March 11th. That would be about sometimes in September, I believe. The United Kingdom and EU countries are yet to sign the convention. The information I have is that apparently there's still deliberation as to whether to join the convention as a bloc or as individual countries. But that's all I can say about that. I think it's important, as I said, a lot of people are not tuned in tonight, are not ADR practitioners. So important, I just want to say, what is mediation? We talk about mediation, arbitration, negotiation. These are all alternative dispute resolution mechanisms. They are alternative to court litigation. So mediation is a flexible process conducted confidentially by a neutral person who actively assists parties in working towards a negotiated agreement of a dispute or a difference, with the parties in ultimate control of the decision to settle and the terms of the settlement or terms of the resolution. Now, there's always a confusion, so I will talk about what is arbitration as an ADR mechanism. Arbitration, on the other hand, is a process or a procedure by which dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision and award, which is enforceable by courts and can only be set aside on grounds provided by law. An arbitration clause is usually provided for in a contract. An arbitrator is a decision maker. You can use a mediator is a facilitator or a person who assists parties to come to their own resolution. And if you can't remember anything else, at least remember that that is the major difference between these two mechanisms. Now, mediation under Singapore Convention is defined rather broadly under Singapore Convention, and it's defined as broadly as a process irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach a settlement of their own disputes with the assistance of a third person or persons, the mediator, lacking the authority to impose a solution upon the parties to the dispute. That's basically what I said, but it's broadly, much broader under this convention. The convention applies to an agreement resulting from mediation and concluded in writing by parties to resolve a commercial dispute, settlement agreement, which is at the time of its conclusion, its conclusion is international. And it is international in the sense that at least two parties have their places of business in different states, or the state in which the parties to the settlement have their places of business is different from either the state in which a substantial part of the obligations under the settlement agreement is performed, or the state in which the subject matter of the settlement agreement is closely connected. That's the scope of Singapore Convention. Exclusions from the scope of the convention. The convention does not apply to settlement agreements for personal, family, or household matters, or family inheritance, or employment law, or a settlement agreement enforceable as a judgment or an arbitration, because this has already been taken care of through the court system or through arbitration. So the Singapore Convention will not apply. A party relying on a settlement agreement under the convention shall have, sorry, let me just get this right. Screen is rather. A party relying on settlement agreements under the convention shall have the competent authority of the party to the convention where relief is sought, if the settlement agreement is properly signed by the parties. These are the conditions that will enable you, make it possible for you to enforce the settlement agreement. If the settlement agreement is properly signed by the parties and there is sufficient evidence that the settlement agreement resulting from mediation, such as the mediator's signature or the administering institution's attestation. A translation of any necessary document in order to verify that the requirement of the convention have been compiled with may be requested by the national courts. This is cross-border. Now, enforcement refusal. What are the grounds that would make a court refuse to enforce a settlement arrived at under the Singapore Convention? And the first ground is a party's incapacity. If the party had no capacity to enter into that agreement, yes, that will work against it, a party's incapacity. The settlement or the settlement agreement being null and void, inoperative, or incapable of being performed, or being not clear or comprehensive. If it's not clear, if it's not comprehensive, you will not, it will be excluded. Now, serious breach, where granting relief being contrary to the settlement agreement, then there is serious breach by the mediator. And then the mediator's failure to disclose circumstances that raise justifiable doubts on the impartiality or independence of the mediator. And where granting relief is being contrary to the public policy of the state where the enforcement is being sought. The disputing matter not being capable of settlement by mediation under the law of the state where the enforcement is sought. These are the enforcement grounds. These are the grounds that will make a court refuse to enforce that settlement agreement under the Singapore Mediation Convention, rather. Now, I took a few minutes to just distinguish the Singapore Convention's refusal grounds from those of the New York Convention. We are talking about two different conventions, but now at international level. Most of the refusal of enforcement grounds in the Singapore Convention, they were largely borrowed from Article 5 of the New York Convention, except those that are unique to the mediation context. And which ones are these? We have already gone over them. Just go back 1 minute. Which ones are these? These ones are E, serious breach by the mediator, and F, the mediator's failure to disclose circumstances that raise justifiable doubts of impartiality. Those two grounds are unique to the mediation, to the Singapore Mediation Convention. Now, under the Singapore Convention, enforcement of arbitration awards rely on the nationality or the seat or the place of arbitration. That's under the New York Convention, which also recognizes the possibility of annulment of the seat, the law of the seat. Now, under the Singapore Convention, a member state's obligation to enforce mediated settlement agreements is not limited to agreements that emanate from another convention state in some respect, such as the location or of the mediation or where the agreement was signed. Settlement agreements under the Singapore Convention, they do not have a nationality. And that's what I mean when I say where they emanate from, whether it emanated from another convention member state, location or mediation. So settlement agreements under the convention do not have any nationality as long as it is international and results from mediation. It will qualify for enforcement, save for the exclusions. That is an impact, that is really a big difference between the two conventions. Now, we have reservations under the Singapore Convention. The first reservation, that is Article 8. If you look at Article 8 of the Singapore Convention, that's where you'll find these reservations. The first reservation allows a signatory state to declare that the convention will not apply to settlement agreements that it is a party to, or that its government agencies is a party to, and is already being popularly referred to as opt-out. Secondly, the second reservation under Article 8 of the Singapore Convention allows a state to declare that it will only apply the convention if all parties to the settlement agreement have agreed that it will apply, and already is being referred to by authors as opt-in. As of January this year, Belarus, which has already ratified the convention, Belarus, Iran, and Saudi Arabia have made reservations under Article 8 of the convention. Reservations can be made at any time. Belarus is already a state party. Iran, not yet. Saudi Arabia, yes. So these are the three countries that have already taken advantage of Article 8, and they have already made their reservations under Article 8. Now, this is what we call reciprocity reservation. Unlike the New York Convention on International Arbitration, the Singapore Convention does not have a reciprocity reservation. Now, what does that mean? A member state's obligation to enforce mediated settlement agreements is not limited to agreements emanating from convention member states. Unlike court judgments and arbitral awards, settlement agreements under the convention do not have any nationality. Settlement agreements can emanate from anywhere. They don't have, it's not like the New York Convention. Under the New York Convention at Article 1.3, contracting states may declare that they will apply the convention to the recognition and enforcement of awards made only in the territory of another contracting state. Singapore Convention does not have that. Now, I'll just go through briefly. There are many issues that are already coming up, but probably I'll just go through a few. Many people already claim that this convention is not necessary because in mediation, parties agree to mediate anyway. I don't know what you think. That's arguments are already coming up, but no. We don't need this convention. Parties have agreed to mediate. Why do we need it? Now, how to secure the mediator's confirmation? That is Article 4 of the Singapore Convention. The this can be problematic. The mediator's signed document by the mediator, this is bound to be problematic, and maybe I will explain. Securing the mediator's confirmation is bound to be problematic in that Article 4 sets out the evidence to be provided to the enforcing court. And that evidence includes a copy, a translated copy of the settlement agreement. That is fine. But the mediator's signature on the settlement agreement or a document signed by the mediator indicating that the mediation was carried out. If the mediation was carried out through an institution like the Chartered Institute of Arbitrators, London, Kenya, any other branch, the evidence might take the form of an attestation by that institution. In the absence of such forms of evidence, any other evidence acceptable to the enforcing court may be produced. Now, whilst the requirement of such evidence may be necessary given the scope of the convention, but the need for the mediator to make some form of attestation to be put before the court as proof is potentially problematic, because in most jurisdictions where mediation is practiced, the fundamental principle of mediation, which is widely accepted, is that parties may not call a mediator to give evidence in relation to a mediation because of the principle of confidentiality. In fact, it's normally said that mediation is confidential and without prejudice, in that you cannot summon, a court cannot summon a mediator to go and give evidence because everything that happened at a mediation session is confidential. So, and then now this new evidentiary requirement introduced by the convention might interfere and or erode the protection currently enjoyed by mediators. As mediators, we enjoy this, we don't abuse it, but now the convention says, oh no, we, not just our signatures, which we put, mediators do sign settlement agreements, but now you can be called, you can be summoned to court. The provision for an option to parties to opt out of the convention, opt out, opt in, by so providing in their settlement agreement could limit the applicability of the convention. This can be disruptive, and especially in large infrastructure contracts, where usually one government is a party and the other government is also a party. So if they opt out, opt in, then this could start limiting the applicability of the Singapore Convention. So that is something that that we want to wait and see how it plays out. This is a new convention, so most of the things we'll have to wait and see how are they going to play out, because now there are only 6 countries that have ratified, 46 have signed. There must be either they are preparing themselves to sign, or what is holding them back, because the success of Singapore convention will really be measured by how many countries have ratified it, how many countries are using it. Look at New York Convention. It started with maybe just about 10 ratifications, 10 signatures on the first day in Singapore, in New York. New York Convention opened out for signatures in New York, and maybe just 10 signatories. But today, the information I have is that it boasts of 168 countries that have ratified it. But that's a long time. That was 1958. Singapore Convention came into force only last year, 12th of September last year. So I suppose we would have to give it some time. My own country, Kenya, has not signed and has not ratified, but it's work in progress. There's already a working committee, a working group that is working towards making it ready, making the country ready for signing and hopefully eventually ratifying the convention. So in conclusion, I want to say that the Singapore Convention is a new international instrument. It's very, very new kid round the block, as somebody told me the other day. It's a new international instrument aimed at facilitating the resolution of international commercial disputes by rendering international mediated settlement agreements enforceable. Before or prior to this convention, such settlement agreements have been enforced as contracts. You get an agreement, then you go to court, so that as you seek enforcement. This is now, that will be may just go on for domestic mediations, but not international mediations. Not international settlement agreements. This is a significant feature previously awarded only to arbitral awards and some court judgments. This convention, the Singapore Convention, complements the New York Convention. As far as I am concerned, I do not think that they are in competition, but they complement each other. Thank you for listening to me.
Thank you, Justice Aluoch, for those insightful and informative comments about the new Singapore Convention. And not surprisingly, you have received a number of questions from the question and answer box. I think much of that is due to the fact that we are plowing new ground here when we're talking about the Singapore Convention. And some of the questions that I'm posing to you actually may require you to use a crystal ball. And so no one will take offense if 5 years from now we find out that your projections were in fact not correct, because indeed this is in its infancy, as you in fact noted. One of the first questions that's garnered quite a bit of interest, and quite frankly, as an arbitrator, it also piqued my interest. And that is this question of the ground for refusal of enforcement based on the serious breach of the mediator. Now, of course, as an arbitrator, we know we have the disclosure obligations that are required by the various jurisdictions. And of course, the IBA guidelines assist us in what we should and should not be disclosing. What is meant by a serious breach by the mediator, and what is the measure of that?
In the in the Singapore Convention, serious breach is not pointed out as to what amounts to serious breach. So it's left open, it's not pointed out, it's not stated. You can't pick the convention and read and find that this is serious breach. But I'm aware of the Chartered Institute of Arbitrators Code of Professional Conduct, and part 2 thereof of this code relates to conduct of members when acting or seeking to act as neutrals. You know, mediators are neutrals. So this part 2, it has several, it says several things, including the code is subject to the overriding requirements that it shall not require a member to act in a way that is unethical or unlawful under any other code or law applicable to the member. So I have a feeling that this serious misconduct has something to do with ethical behavior.
Well, you raise a wonderful point, because all of us in the Chartered Institute are in fact subject to that code of ethics in everything we do. And we do think that that is one of the hallmarks that sets our organization apart from other organizations. So your reference to that is very comforting. And I guess any mediator would also be subject, assuming the mediator is a member of a particular bar association, would be subject to the bar association rules as well. Obviously, this appears to be one of those points that we're going to have to wait and see what develops over the years. Another question that has been raised by a number of people relates to whether or not, in your opinion, the Singapore Convention on Mediation has introduced any practical changes to the mechanism of enforcement of mediated settlement agreements, which would significantly, streamline the process, both in jurisdictions that already use mediation and those that don't.
Okay, the fact that settlement agreements, let me give my country as an example, because we have not yet signed or ratified. A settlement agreement that is arrived at here in Kenya, it can now be enforced into a country that has ratified the Singapore Convention. That is a new development. Before you would enforce it as a contract, but now there is that new dimension to it that the Singapore Convention has brought into light.
And of course, we have that in almost every domestic situation in which, if there is a breach of a settlement agreement, what you end up doing is going and suing in the court for breach of contract. And one of the things that the Singapore Convention is also doing for us is eliminating the issue of obtaining jurisdiction over someone. Because if in fact you had parties from 2 different countries and you wanted to sue on that contract because of the breach, you could have a jurisdictional issue as well. So it does seem to be a very excellent means for bringing things to closure a little more frequently. And I know that in my own practice, there has always been a resistance to mediation on the basis that there wasn't really any enforcement provision. It was always
mechanism. Yep.
You had to just depend on the goodwill of the party.
That has played against mediation for a long time. Yeah, that's true.
And you mentioned this lack of no requirement of reciprocity. Are you aware of any discussions that were had at the working group on that point? I mean, you know, under the New York Convention, there is the ability to require reciprocity. So we're interested in, was there any discussions that you're aware of?
I know there were some discussions, but I don't have the details of the discussions, but there were some discussions, yes.
Now, mediation, of course, is a highly localized practice, and that can vary from one jurisdiction to another in how one goes about mediating and whether or not, for instance, it's annexed to courts and so forth. Do you think that the Singapore Mediation Convention might open the door to a more global standardized mediation practice?
Yes, I think so. My answer is yes, yeah.
I'd be interested in knowing what format does mediation typically take in your country, for instance, Kenya. In the United States, we do caucuses and we do a general session, and it's very formalistic. Is there a particular manner in which mediations are conducted in Kenya?
Yes, we have private mediations, we have court-annexed mediations, and we have preliminary meetings, and thereafter we have the day of the mediation session, joint session, and thereafter private sessions. I know you in America it's caucusing, but we normally we call it more where we use both caucusing and private sessions.
And in Kenya, is there a requirement of specialized training for one to be a mediator?
No, because we have mediators from different backgrounds. We have mediators, not just lawyers. We have different backgrounds, different trainings to become a mediator, because we have mediators in different fields. For example, some parties prefer a mediator who has a background in their dispute. Maybe they have, yeah.
But you anticipated one of the other questions that had been posed was whether or not you believe someone with legal training is a better mediator or is someone without. And what I'm hearing you say is it depends on what the parties need.
Yes, that is true. It depends on what, maybe it's a construction matter and it's gone for mediation. Some parties would require a mediator with that background. It doesn't mean that that mediator should take advantage of the parties just because he or she has that background. But some parties tend to agree that no, we just need a mediator that has relevant background, relevant training. That group would not be asking for a lawyer. No, they're looking for somebody with the relevant background in their field. They choose, because mediators choose, parties choose who the mediator is, who their mediator or mediators are.
And is that true? For instance, in the United States, there are instances in which if the parties are reluctant to go to mediation, the court will just assign a mediator. Do you have that happen in your country?
Under the court-annexed mediation program, which is now a permanent program in our courts, normally the judges would look at the matters. If it is a matter that is that would be suitable for mediation, they would make such an order that this matter is suitable for mediation, so it is sent to mediation. In that way, sometimes people say this is this is compulsory mediation, but the fact that there's a court order, once you get to the mediation table, it is the mediator takes over. So if the parties are free to say, we came here, we don't want to be here, but most mediators would find their way of convincing the parties to stay and get the process going. Facilitators, yeah.
Having been in that situation before as counsel to a party in which the other party didn't want to be there, I can assure you, I know that the mediators do know how to keep everybody there and keep everybody talking. One of the issues that you raised relates to the confidentiality of the mediation, coupled with the fact that the Singapore Convention has ways of having the mediator attest to the fact that this was a mediated settlement agreement, and that raises all sorts of confidentiality concerns. And I can tell you that from my own personal experience, I recently was involved in the revision of the International Center for Dispute Resolution's arbitration rules and mediation rules, and they make reference to the Singapore Convention. And they make reference that the mediator has the ability to make that particular attestation. And it caused concerns when we took it out to the public because of the confidentiality aspects of it. And I'm interested in this time, I'd like for you to look into your crystal ball a little bit. What do you think is going to happen with that particular point? And how would you, as a mediator, given the request to go ahead and make this attestation, how would you go about doing
that? Before the mediation session starts or during the preliminary meeting, I would talk to the parties so that we come to some sort of agreement that we keep the confidentiality as we know it, and that I should not be summoned to court to disclose what we discussed at the mediation session. I can see a lot of mediators maybe doing that, because there are situations where mediators might say, well, if I'm going to be called to court because I've signed, I'm not signing. But mediators are not like that. That's not part of mediation. No.
Well, I know that I have gone to some mediations in the past where the mediators actually have you sign a document that says that they cannot be called as a witness, and they track the statute that we have relating to the fact that they can't be called. So I do think it's an interesting point that obviously is going to have to be developed further, and does apparently give some, shall we say, heartburn to some mediators that they might have to suddenly find themselves embroiled in a controversy. We've got another interesting question here that says, I've heard criticism from some experienced mediators that they believe the convention will result in international parties being less willing to mediate if it's possible to enforce against their assets immediately abroad. Do you agree with that concept?
No.
Okay.
I don't agree with that, no.
Well, of course,
I think, the fact that this convention is specifically for commercial disputes, and people in this field want things to move quickly. They really would like, as much as possible, to avoid going to court and mediate their disputes. And that's why I don't think I would agree with that, yeah.
Well, mediation is a consensual process, so you're probably right on that particular point, but I could certainly see there could be some reluctance on some parties with the idea that they're not going to be able to buy the time, shall we say, that they would have been able to buy previously if they had simply a mediated settlement agreement that couldn't be enforced. I think we have time for probably just one more question. And let's see what one we might want to ask. We have so many good ones here. This one is more of a technique, and I think we're probably interested in what your technique is, and it kind of gives a global perspective to it. It says, basically wants to know who drafts the settlement agreement in a mediation matter. And what is your experience? As a mediator, are you drafting that settlement agreement? Are the parties drafting it? It's a combination. What happens?
Personally, as a mediator, I use a flip chart. And after, when I'm satisfied now that the parties have arrived at a settlement agreement, I normally would use the flip chart and write down what they have agreed. and make sure, because that is that I'll do that in the room where I am, where everybody can see it, and then it's only then that this can be reduced into, that can be typed out. I find that works well for me, because settlement agreement, the flip, I will always have a flip chart when I'm conducting a mediation session. I use it a lot, yeah. Because if I write one and this is what the parties have agreed, and then I'll ask them, check it, read it. Is that what you have agreed? Somebody will say, oh, yes, we agreed on that, but please add this. So I find a flip chart very useful for during the sessions, yeah.
And who reduces that agreement to writing? Do you undertake that, or you have the parties do that?
If they are lawyers, and most parties are represented, I would ask the lawyers, but I would ask them to do it right there in front of everybody. Yeah, I'd like to give it to, I'd like the parties to participate, to be involved right to the end without holding. I don't, for example, I don't tell lawyers that go and draft this settlement agreement. If they are drafting it, it's somewhere, some place within my site, and they bring it back so that I can check it. And that's why, as far as I'm concerned, a settlement agreement must be drafted that same day, immediately. Yeah.
And would the point about whether or not you are going to certify, for lack of a better word, that this agreement was the result of mediation, is that something that would be mediated as well during the course of the mediation? Whether your signature is going to be requested?
Well, what I do is the parties sign, and I, as the mediator, I sign the agreement, the settlement agreements, because that's how we practice mediation out here. The parties' signatures and my signature as a mediator.
Well, that's interesting, because I know in some jurisdictions you would not see the mediator's signature. And one of the issues that I've heard people say is that, in fact, you would need to go ahead and actually mediate the question as to whether or not the mediator was going to sign to make it in compliance with the Singapore Convention, to add just another layer of complexity to the entire process. I've been told we have time for one more question, and this one says, they're picking up on my question relating to international arbitration procedure has sometimes been criticized for being too common law guided. Is international mediation going down the same route? This person is from a civil law country, and mediation is still an unknown creature to many of their practitioners. So you and I both come from common law countries, so yeah. And it is become very common for us. But do you have any advice for the civil lawyers that are out there that are unfamiliar with mediation?
What is their fear? The people from civil law countries, what is their fear? That mediation is going to go down?
I think it's probably a fear of the process itself, because it is an education, as you and I know, to get people comfortable with it. To the person who posed that question, I think maybe you could be one of the standard bearers for your particular jurisdiction about.
I think the fact that in mediation, the parties control the decision to settle. I control, as a mediator, I control the process because I have the skills of a mediator, so I control the process, but the parties are responsible, are in charge of the decision to settle. If I were to say it loosely, I would say they come to a decision that they can live with, because I've taken them through the process, I've assisted them, and they finally are the decision makers. I think that is, to me, that is the most important thing in a mediation, that these parties are the decision makers under my guidance. Yeah.
And I would like to ask you one last question. I keep saying last questions, and you know that's what lawyers do. They always tell the judge they've got one last question. You know that, you've been there. We sometimes see mediation before people go to court, and we sometimes see mediation during the court process. Do you believe that one procedure is more effective than the other, or do you find they work equally well?
I know that in many countries, I think even our neighboring country, Uganda, they are our neighbor, that the process that people go through, the requirement is there that they go through mediation first. But we don't, that's not our practice here in Kenya. And it depends, really, it depends. If that's a requirement, then you'd have to do that. But then that would only, I don't know whether that's a requirement even in private mediations in Uganda, because private mediations, they've come to you to help them settle the matter, to assist them. So you can't tell them, go to court first, then come to me afterwards. I don't think you can do that. But in Kenya, private mediations, you know, there's no requirement that they go to court first. But mediation under the court annexed mediation program, these are cases that have been filed in the court. The judges scrutinize them and find that they are suitable for mediation. And I think last year there was a further directive that parties can go and request that their matter, which is pending in court, can be referred to mediation. So I think it really depends. Really.
And we see also that some of the arbitral institutions have mediation rules and try to get the parties to mediate during the course of arbitration as well. So I think that, you know, we need to realize that this is just another tool that can be used with the courts and can be used with arbitration as well. Well, thank you for all of your comments today and also for answering these questions. We really appreciate it. And if I may now, I would like to make a few closing remarks and thank you and thank our audience for the time that you gave. I was struck, Lady Justice, by your comment that the Singapore Convention and the New York Convention complement one another rather than compete. And I think that statement is especially welcome. As dispute resolvers, I think it's important that we not only offer to the parties, but also endorse all means of dispute resolution. I was struck while you were speaking about a phrase I had heard once that said, an ounce of mediation is worth a pound of arbitration and a ton of litigation. And that saying is especially true, not only because of the cost savings, but also because through mediation, the parties can reach business solutions that actually are unavailable through arbitration or litigation. And I personally think that is indeed one of mediation's strengths. Mediation, of course, has a long history. Some scholars opine that it actually began in ancient Sumeria during the time frame of 4,500 to 1,900 BC. In the Sumerian society, there was an individual called a mascom who was charged with weighing the merits of each case and assisting those quarreling parties in resolving their dispute. If the mascom could not broker peace, the case went to court, a role not unsimilar to a modern day mediator and your role today, Lady Justice. Africa, Asia, and the Middle East, of course, have a long history of mediation. And we have talked a bit about how the courts in the United States handle mediation. And in fact, in the United States, mediation was not embraced until about the 1980s. And given my home state of Texas and its reputation for not only gunslingers, but also very aggressive plaintiffs bar, it might surprise you to learn that Texas was one of the first states to enact a mediation statute and that virtually every case is mediated. And of course, and perhaps the most well-known mediation story is the one of the two women before King Solomon, with each woman claiming to be the baby's mother. And his solution, as we all know, was to suggest that the baby be divided in half, which, as the story goes, revealed the true mother who was against such a resolution. And of course, has given us also that derisive term that is assigned to arbitrators, that they divide the baby. Lady Justice, I noted that you currently stated that there are only 6 countries that have ratified the Singapore Convention, and that those 6 countries would soon be joined by Turkey. And I do think that some may deduce from the fact, and you alluded to this, that the Singapore Convention will not be successful. But I, like you, suggest that that assumption is wrong. If you look at the New York Convention, which is arguably one of the most successful conventions, it too had a somewhat slow start. Comparing the time period that the Singapore Convention came into force with the same time period for the New York Convention, the New York Convention had a similarly small number. And although the New York Convention came into force in 1959, surprisingly, it was not ratified by the United States until 1970 and by the United Kingdom in 1975. And I think, as we have discussed here today, we shouldn't overlook the fact that the Singapore Convention fills that important lacuna, the enforcement of the settlement agreement, so that one does not have to sue for breach of the settlement agreement. As dispute resolution practitioners, we owe thanks to those who were instrumental in making the Singapore Convention a reality. The Chartered Institute of Arbitrators participates as an observer at the UNCITRAL working groups, and we know firsthand the dedication and work that each new convention represents. The Singapore Convention, together with the New York Convention, further the Chartered Institute's arbitrators' mention of promoting access to non-court dispute resolution. Lady Justice, I want to thank you personally for shedding further light on this most important development in the field of alternative dispute resolution. You might be interested in knowing that your presentation represents only the 2nd time that our Roebuck Lecture has featured mediation, and we hope to feature lectures on this topic in the future. Mediation is clearly of interest to our members. In fact, you may be interested in knowing that because of this virtual format, over 500 people were in attendance this evening, once again demonstrating the power of the internet. Before we close, I should like to remind our audience of the Chartered Institute's upcoming flagship events, focusing on various aspects of dispute resolution. On October 7th, the Chartered Institute is hosting its Mediation Symposium. In November, the 2nd of our lecture series, the Alexander Lecture, will be held. This will be the 47th Alexander Lecture. And the year is going to be rounded out in November with the Dispute Appointment Service Convention. I do hope that many of you will attend. And finally, I wish to thank each member of the audience for being part of the Chartered Institute community. Thank you again, Lady Justice, and good night all.